one matter.
My
Lord, the two writ appeals, moving it for the end of the list today. The urgency is this, my lord, the assistant commissioner's order has been upheld by the learned single judge. Now the assistant commissioner has gone into the aspect of deciding title to the property, my lord, which is not empowered to. Now, my lord, by virtue of that order, they are trying to trespass and alienate, my lord, the property. There is a threat of alienation. My lord, if this, my lords, if my lords may grant me leave to move the vacation bench, my lord.
You can move subject to you satisfying the learned vacation just for urgency.
My lords,
What it prevents?
my lords, the problem issue is this, my lord. The scrutiny branch will not scrutinize my appeal until unless there is a memo with an endorsement.
Why it will not proceed?
My lord, because it is filed yesterday, my lord. That is before the vacation, my lord.
There is an issue, my lord.
Only vacation
Yes,
filed in
those
the
which
vacation.
are filed only post vacation.
Post vacation, my lord, only
Will
those
get
are
this.
scrutinized.
No, the vacation matters to be moved before vacation judge are necessary to be filed during vacation only.
Yes, that's the norm here in Karnataka.
That we will change it.
Yes. Now, my lord, suppose a matter is filed before the vacation, it doesn't get listed.
So pending matter can be moved.
No, no. Of course, pending matter can be moved by mentioning, but it is the rarest of rare chances that they take it up. But matters which are freshly filed, they automatically come up. That's some difficulty there.
That I know that will automatically, but other matters will not be posted.
It will not be posted. Suppose not we file a IA also, it's an old matter, it is not posted for urgency. The lordships may direct it. Those that get numbered before the vacation get stuck.
What is your urgency?
My lord, the threat of alienation, my lord, by virtue of learned single judge's order, assistant commissioner order has been upheld where he has gone into deciding the title to the property, my lord. Now, based on that particular order, they are trying to alienate the property, my lord. And Khata has been directed to be mutated in their favor.
Yesterday we had passed. So endorse on the memo that liberty is granted to the petitioner to move learned vacation judge, subject to the petitioner satisfying about urgency, satisfying the learned vacation judge about the urgency.
Obliged, my lord.
My lords, the matter is before the single judge, my lords. Subsequent bail petition that has been filed by this petitioner. My lords, the difficulty is about listing the matter before the single roster judge, my lords. Now the judge who has heard the matter, decided the matter, there we had withdrawn the petition. Now the judge is sitting in Dawan, my lords. My lords, the lordships have told that she'll not take up the matter and let it go before the roster bench. My lords, but the difficulty is it's been 2 months that the matter is not listed, my lords. I've been trying to move the matter from here and there, but it is not getting listed, my lords. They want a special order from your lordships to get the matter
There
listed.
is a circular already issued.
My lords, I have attached
In
the
light of the
circular and
recent-
move the matter.
In light of the recent Supreme Court,
Yes, my lords, the circular, I have attached the circular, even then the matter is not getting listed, my lords. That is.
put up before. Ask the RJ. Not here. You go there. Not here.
My lords, I have gone to registry and inquired, my lords. The registrar has told,
Register judicial.
the registered judicial has told that they have put up file before your lordships.
You go.
To,
You just remind. We'll pursue it.
My lords, I have been pursuing
We'll
since 1
pursue
month.
it. I'm telling we'll pursue it today itself.
My lords, only last day working is on 2nd, my lords.
Administrative, this way cannot be made in the open court. You go to this judicial, we'll pursue it
Okay,
on the administrative side.
much obliged, my lords.
We'll take follow-up action right now, today itself. Yes.
My lords,
Much
WP 11397/25, my lord. This is the Hubli encounter case, my lords. Yesterday, my lords was pleased to reserve it for judgment. We would like to place some citations, my lords.
It is not reserved, it is kept for orders.
Orders, my lords.
Not reserved.
Please.
Kept on second. Whatever you want to give
There's some citations that we would like to
on
place.
behalf of petitioner.
Petitioners.
But one, yesterday's matter, where your lordship directed notice, there was a election to the Waqf board, contrary to the directions of this honorable court. The lordship has directed notice. There is some urgency, need liberty to move the vacation back.
What of the subject matter?
that was the Mutawalli was elected to the office of the Board of Works, though he was ineligible. And it was contrary to the directions of this honorable.
Like liberty endorsement on the
Yes.
liberty is reserved for the
Adjournment
petitioner
movement
to
होता
move
है
on a
ये
single
क्या
judge,
होगा?
subject to satisfying the learned vacation judge about it.
Permission, this is commercial appeal that is filed this morning. But last evening, the commercial court has issued an anti-arbitration injunction restraining a London Court of Arbitration from proceeding. That can't be done, the Supreme Court has clarified it. And what is worse, is that another coordinate bench of the commercial court says that the arbitration clause is valid. This bench comes to the conclusion, that there is no arbitration clause and therefore there is some difficulty, because the arbitration is pending and is at the final stage of constitutional development. And there is some urgency, if possible today at the end of the list or of the second.
More time. Yes,
My lord,
not possible. Yes.
my lord,
Yes, Mr.
in the Raichur district, my lord, in the district of Raichur in Karnataka, in Raichur city, there's an educational trust, my lord, which has been giving out degrees from the past 10 years without recognition from the statutory body. And we have obtained information through RTI from the statutory body saying that they have withdrawn the recognition given to that educational institution. Now, my lords, they have again issued an advertisement wherein they are recruiting the students for the educational institution, my lord. And they've been operating without recognition, which constitute an offense under the state law. Therefore, my lords, we have filed a petition, my lords, in the nature of public interest. We want it to be listed, my lords.
14th July.
14th July, my lords. Yes, my lords.
Contempt petition, my lords. There is an order of status quo. Yet they are constructing, my lords. There is a threat of violation if they complete the construction. They are construction day and night, my lords. Any date, my lords. Contempt.
The date can be given. 21st July.
June, my lords, if I'm right.
Not possible.
This was a matter, my lord, where lordships had directed it to list it on Monday, my lord. Where this was a matter where my lords had directed this matter to be listed on Monday, my lord. My lord, this was a case where the action was sought against the notary and the advocate who had forged this lease deed. An action was sought against the notary and an advocate who had forged and had passed into the possession. My lord, the central government had undertaken that they would take an action in the month of July itself. My lords had ordered it on Monday itself, my lord. It has not come up.
Why it is not?
Yesterday we checked up, my lord. There was some administrative.
Office of the.
No, we have complained. Officer complied. Only the deputy registrar had to, my lord. No, I mean dispensation was to be granted, so it can be taken up any day, my lord, on second or at the end of the list, because the very prosecution of them would, my lord, would become futile, because already it is 4. I mean,
Why you are not circulating, though permission was granted
my lord, we did mention, my lord, there was due to some positive.
yesterday?
Yeah, they did not list it, my lord, in the.
Not pursue.
No, we did pursue, my lord.
So why office should not? Why office unposted?
There was some crowd, my lord. There was a lot of, my lord, rush in the branch.
There is no ground. Rush is not the. Who is circulating? Why it is not circulated yesterday? Call the officer. Though there is an order of the court. Who is in charge of the circulation? He must be here at 2:30. You can't not pursue and then pursue the court. You are equally guilty.
I leave it to the court. I'm at the answer of the court.
All like second.
Commercial appeal number 121.
Yes, Mr.
My lord, serial number 16 and 17.
16
Short
and-
accommodation, my lord. Is the
All
volume-
accommodation is granted. No mentioning necessary. Only adjournment will be taken up. Yes. 180. 20.
There's one more appeal that has to be connected. They request for an adjournment and to be tagged along with this matter.
You get that matter, which was to be listed yesterday, but not listed in the recess. Get the papers. Yes,
Seal number 25, my lord. I appear for the appellant,
yes.
but there's one more connected appeal which has to be tagged along, my lord, but it's not listed today. I request for an
Stated that the
adjournment.
Cognate appeal number,
Commercial appeal number 130 of 2025. my
cognate
lord.
commercial appeal number 1 so and so is to be listed together. Both shall be listed on
Any date after vacation.
after vacation.
1 second, sir.
15 July.
Grateful, my lord.
Yes.
I oppose the.
Yes, madam.
My lord,
commercial appeal number 121/25.
Oh.
It was covered before the court, Your Honor, 27-3. But commercial court passed the movable attachment warrant, Your Honor. I have enclosed the online order sheet, Your Honor. But yesterday I have filed the application in view of the urgency, Your Honor. Kindly put up the matter to the second, Your Honor. I have enclosed the order copy, Your Honor. Attachment of the movable warrant.
Liberty to move the law and vacation judge if there is an urgency by satisfying law and vacation judge about the urgency.
The serial number 39, my lords, on behalf of appellant, my lords. Kindly have it after vacation.
39, all 39 after vacation, all right. 39 will go to
My lord,
requested by law and appellant, stand over to 10th July.
My lord, serial number 101, my lord.
101.
101, appearing for the respondents in this case, my lord. Kindly adjourn the matter of the vacation.
At the request of law and appellant,
Respondents, ma'am.
stand over to 16th of July.
Much obliged.
My lord, 143. My lord, in one review petition which was reserved on Friday, my lord, after being heard. My lord, in that, the provision that was mentioned was wrongly mentioned by me because 23 years it had not been, that tongue had said 6, the regulation 6, but it is actually regulation 18.
Sports code.
Pardon?
Sports code.
Yes, that's right, my lord. So I'm just placing the correct provision along with the rule itself. It may be taken on record.
Serial number 50 oppose the adjournment, my lord. 18 to 25, the compliance report has been submitted.
Refused.
No.
Yes, Mr. 20.
My lord,
50. You want
your
time?
lordship, kindly, whatever the compliance report is filed on 18 to 25.
So you are in 50.
Yes, my lord.
What is the request?
My lord, compliance report is from 18 to 25. Even you obtained the mandamus by producing a fabricated document before the honorable single judge.
After vacation. 11th July. 11th July, yes.
Serial number 15, my lord.
15, yes.
You may have it, your lordship, after vacation.
Yes,
You
15.
have an adjournment. 15, and you may have it after vacation.
After vacation.
My lord, in compliance.
18th of July.
My lord, serial number 143, my lord.
My lord,
143.
143.
143. Yes. PIL.
Yes.
About what?
After vacation.
About what? It is PIL about what?
We are for petitioner.
My lord, it's for installation of a statute in a public road. I have to file the report of the DC.
After.
Lord, serial
10th of June.
my lord, in that serial number 50, there is nothing much to be heard. The compliance affidavit has already been filed. They had obtained the writ of mandamus only on the basis of an LRF fabricated document, my lord. By virtue, even in RA court also, the case has been dismissed. They have misguided. My property, they've obtained an LRF order by fabricating. Compliance affidavit already been filed. Every time they have been taking the adjournment, my lord. There is nothing much to be heard at all in that.
Well, I take chance if you are objecting. Don't
Grateful,
adjourn.
my lord. Grateful.
Kindly. Serial number 131. But after compliance, the office has raised 2 more objections. One of which is deficit court fee. The court fee is made good. I'll verify with the office that whatever office objection is remaining, 2 days time I'll come.
So serial number 113.
131.
110.
131, serial number 1.
110 to 119. Unless the office objections are removed within 4 weeks from today, the appeal or petition or whatever shall stand dismissed automatically without reference to or order of the court. And 120 onwards up to 131. In each case, times to be granted is of 2 weeks. Then 132, Then we'll see after.
My lords. Serial number.
Dear Lords, kindly serial number 16 and 17, my lord. Office objections are complete. Kindly weeks accommodation. 6 adjournment, my lord.
6
Time, my lord.
time 16 and 17 as requested by
Appellant.
the appellant. Stand over to 23rd July.
Please.
But serial number 13, my lord. 1-3.
13
I request for a week's time in this matter, my lord. 1-3.
at the request of learned of the
Appellant, my lord.
appellant. Stand over to 17th July as requested.
Obliged, my lord.
Any other mentions through VC, sir?
Nobody is there. Very second book. No.
Sir, list number 3, this is for pronouncement of judgment in writ petition. Seal number 1, writ petition 23615 of 2022.
23615 of 22. The petition is dismissed.
Seal number 2, commercial appeal 84 of 2025.
Appeal for the appellant.
Commercial appeal 84 of 2000. Commercial appeal 84 of 2025. Appeal is allowed. The order impugned dated 3/2/2025 is set aside. The interim order dated 21/24 is confirmed and continued till disposal of petition under section 11 of the act pending before the court.
Much obliged.
So, list number 2, seal number 1, Mr. Chandrasekhar L.
I request for pass over the matter.
The podium duress.
Please. I
Yes, sir.
request for pass over.
Why?
Can be taken. Lord, I'll file affidavit of compliance.
2:30.
12 o'clock.
2:30.
Please.
If by 12 o'clock, yes, then if you are getting the video, that's 2:30.
Please. Grateful.
This is seal number 2, Mr. Krishna S. Vyas.
Appearing for the petitioner in this matter, my lords. My lords, there has been a affidavit which has been filed, or rather a memo along with objection statement having been filed by the respondent, my lords, wherein they state that this layout approval, what has been granted.
There is no urgency. 8th of July.
Well, nothing will
Much
survive.
Nothing will survive.
Nothing will survive, my lord, because their contention is that, my lord, a sanction plan has been issued to, my lord, to the respondent for construction of a commercial building with 25 meters from the center of the road. My lord, yesterday I had filed a memo along with communication from the deputy commissioner.
Yes, it is that matter.
Yes, my lord, this done matter. My lord,
My lord,
internal
this is-
page 3, paragraph 5.
My lords,
My
as
lord,
it is an, my lords, as it is an admission before this honorable court that the layout plan has not been appropriately issued, my lords, petition may be allowed, my lords.
Very good. Yes. This is disposed.
Right.
Much obliged. This is seal number 3, Starkash VT, the PL.
Lordship, this is the issue of the smart meter which was taken up yesterday. Your Lordship said that you have it today. Lordship.
Appealing for the respondent.
Might I request your Lordship to take up page 247, Your Lordship? This is the Gazette notification, Your Lordship. And at page 250, Regulation 3. Lordship may kindly see applicability and procedure for availing facility under prepaid meters. These regulations shall be applicable to all categories of consumers, new and all existing consumers. Provided that availing power supply through a smart prepaid meter shall be at the option of the consumer except temporary installations for which it is mandatory. So, Your Lordships, what they have stated in their regulation is that it would be applicable to both new and old customers. And then the proviso says that provided by availing the power supply through a smart prepaid meter will be at the option of the consumer. So now they're trying to say it's at the option of the consumer, but while one applies for a prepaid meter. Now might I request Your Lordship to turn to page 113, which is the operation guidelines. The guidelines, Your Lordship, will be contrary. Page 113, if Your Lordship may kindly see.
Okay. If I don't intervene, my lord. Connected writ petition to public interest are pending notice after vacation. One more important fact, my lord. Similar petition, same pleading filed before the single judge by the same counsel and matters listed today. Clear case of abuse of process of law, my lord. They are not able to obtain an interim order before Your Lordship in two public interest. They filed two separate writ petitions before the single judge, which is listed today. Pleadings copy paste of this petition, my lord. I'll point out. Your Lordship may kindly see this is a petition filed before the single judge.
But one interim order is also granted by single.
Correct.
Without disclosing the facts. Your Lordship,
That is.
that I'll argue before single, but this petition has to be dismissed.
Yeah.
Or why should we enter in this when learned
Please.
says with the matter?
Correct.
Yesterday also we told you, madam.
Your Lordship, those are, might I point out two issues? The issue of the tender cannot
Is
be
that matter?
raised. Please, Your Lordship.
Which is the writ petition where the learned single granted the interim order.
WP number 12987, my lord. Show the order sheet.
And that interim order is only with respect to the consumer for his
There are
particular
other
billing.
petitions also filed.
Yes, two writ petitions.
There are two
pending,
writ petitions
which,
that are
which my
pending.
learned
It's
friend
there.
is appearing in one, my lord.
Yes, in one, and that's listed today. And his lordships are aware that the PILs, this is what they had mentioned, Your Lordship.
Can't have both the fronts.
No, Your Lordship.
You can't have both the fronts in one PIL and private.
No. Your Lordship, there are two different issues. Tender matters cannot be raised before the single bench. Whether the tender is correct or not can only be raised in a PIL.
So go before the division bench where tender matter is raised.
Your Lordship, the issue is not about the tender at all.
Where it is raised or where it is not raised is not our concern. We are concerned with the fact that similar controversy or controversy akin to this or controversy arising from these facts is pending before a single.
Single judge, what is pending is on a similar issue, absolutely.
Which
But
are
it
the
is,
which
Your
are the
Lordship, what happens
WP
in a
number,
single?
WP number 12987.
One by one.
I'm sorry, my lord.
12987 of 25 when the order is granted.
The order is matter in this matter, which my learned in that matter, my learned friend has appeared day for yesterday.
There
It is
is
listed.
no, there is no order.
Let me come.
Interim order is granted.
Interim order is granted in WP number 12535 of 2025.
When granted?
Granted on 25th April 2025.
If the learned AG could read further as to what the interim order is.
That is this, that is one. Then this 12887, 12987, 25 is what?
That no interim, my learned friend argued.
Same.
Impugned annexure B is similar to that. What is prayed here? What is prayer in this petition? Prayer B is, my lords, in single judge. Prayer C, your lordship may kindly see. Prayer C, my lords. That is is similar to prayer B before the learned single judge. Facts are identical, grounds are identical, relief is identical.
Parties also.
No, counsel, not what.
So the prayer there is to set aside the operational guidelines.
Yes, my lords.
For smart meter.
Please, my lords.
Your lordship, two petitions, PILs that are filed
Any
here.
other petition?
Please, my lords.
Any other petition?
No, two other PLs which are there posted after vacation before your lordships.
Which are there?
Their writ petition numbers are, my lords. Totally WP number of 9437 of 2025 and WP number 8654 of 2025.
And 9437.
That is
Notice is issued.
In one notice has been issued, my lord, that is 9437 2025. Notice was issued by your lordships on 24th April 2025.
Both the PILs, your lordships, have been filed challenging the contract awarded to a particular person. It's not gone on the guidelines at all. In that, your lordships have issued notice. Now, the matters that are pending before the learned single judge is one with respect to individual who's affected by purchasing that meter, and also with respect to how the guidelines are contrary. Your lordship, what happens in a PIL is that in a writ petition, an individual, unless and until, was a partaker in the tender process, and he is the person who has not been the successful bidder, can challenge it with respect to the tender. Nobody else can challenge in a writ petition. Before in the PIL, we have challenged the entire tender process, the fact that there is an entire bias in favor of one particular successful bidder, and that can be only gone into in the PIL. Now, your lordships, I have no objection if this matter is to be taken up later and the writ petition is to be heard first. That is not an issue. But to state that both are on the exact issue, your lordship, that will not be true, because before the single judge, we will not be able to raise issues with respect to the fraud that has taken place in the tender process. That cannot come up before the single judge. That can be only by way of PIL.
What a preliminary objection is, my lord, abuse of process by the petitioner. My
There
lord.
is no abuse of process. In fact, the abuse is by putting up dummy PILs deliberately so as to ensure that there is no relief in those PILs. And those were readily produced before the learned single judge.
My lord.
No, petitioners are also same.
Not petitioner. Counsels who filed before the single judge and this petition are the same. They are fully aware of this PIL. Relief is same. Pleadings are same. Grounds are same. Prayer is the same.
We have stated
Nothing
before
but
the
abuse
single
of
judge
process
that
of
we
court.
have a matter, the PIL. This has also been mentioned also before the learned single judge. Learned single judge is
We don't know
also
who's right
aware
or-
of the difference in both the matters. Your lordship, an issue of tender cannot be taken up before the learned single judge. Only a person who's taken part in a tender and is not a successful applicant there can proceed before the learned single judge. Both the petitions before the learned single judge are with respect to the persons who've applied for a smart meter.
Can you get the filing dates of these petitions? Petitions, yeah. Not this. Date of filing will be- okay.
Have taken this. I'm giving it to Abdul.
1, 2, 1 is not. So 5. And 1 second. 1, 2, 5, 3, 5. And date of filing. Are you inviting order?
Please, Your
We are
lordship.
not absolutely not inclined to entertain, but we may come very harsh, and we are searching of the sequence of filing of your petition one by another, whether by you or not. But you know that the petitions are filed earlier, notice is issued, no interim relief granted. In some cases, identical reliefs are paid for and sought for in the petitions before learned single judge. And now at this stage, you are moving this PPIL, which is really abuse of process
It
of
is,
law.
it is
We-
in fact quite the
Are you
contrary.
inviting order?
Your Lordship, might I for a minute? 2 PILs that has been filed are in fact deliberately filed without even challenging the guidelines, only on the aspect of contract being awarded, which conveniently they wanted it dismissed. Unfortunately, it was not dismissed and notice was issued. Your Lordship, this is all stage managed to ensure that whatever happens, the smart meter issue is not touched upon. Your Lordship, this would be quite harsh to state that, in fact, we are trying to overcome the difficulty that they have placed to PILs deliberately at the earliest stage so that they would be dismissed. Those have not been dismissed. The matter in which interim order has been granted by the learned single judge is another issue altogether. It's with respect to a single petition. In fact, your Lordship can even pass it over. The once the matter is over, we will even come back before your Lordship. But to say that this has been filed deliberately, in fact, it's quite the contrary.
In the other PL also, the prayers are the same. So challenging the same relief.
No. I will read out the prayers in those PILs.
Your Lordship,
They are
can you
with
take the
respect to
petition?
the contract.
Take the petition. I've got the petition copy. Prayers are I didn't take it.
They will have the petition copies, of course, because these were all stage managed.
Great respect, let her not
The
make
prayer in the writ petition that they had filed over here, your Lordship, quashing the contract award. Your Lordship, this is the order sheet, your Lordship, of the matter before your Lordships. This was in the writ of certiorari, quashing the contract award, and such other writ as deemed fit. Might I pass on the order with respect to the prayer in the other PIL, your Lordship? Your Lordship, I've just opened the other PIL also. Even their prayer is with respect to quashing the circular, your Lordship. In both of these, they have sought for with respect to the contract being awarded. Both the PILs. Give me our petition. Yes,
So to the extent the prayer,
Yes.
Please.
Would you like this petition to be listed along with other PIL where
Please.
notice is issued?
Please.
Would you like to argue or are you inviting order? That's all.
This can be listed along with the other PILs, your Lordship.
Learned senior advocate, in course of the submissions, fairly considered that 2 other PILs, which is writ petition number 437 of 25 and writ petition number 8654 of 25 are filed, which touches the same subject matter. in which the court has issued notice. He requested that this may be listed along with those petitions without going into the merits. And in particular, without expressing anything on merits. The present petition shall be listed along with writ petition number 9437 of 25 and 8654 of 25.
Obliged.
Yeah, for the petitioners, my lord, the petition is filed challenging the impugned notice at annexure A, my lords, which is demanding, my lords,
No urgency.
precipitative.
8th of
no-
July.
my lords, no precipitative action may be taken, my lords. There is an one submission. It's a demand notice on environmental compensation. The issue has been dealt. It may be
Covered by.
Covered by. My lords, today they were not able to produce a judgment copy, my lords.
Right. Yesterday's matter.
Please.
We don't have time even to deliver the orders because. Yes. On same terms, same operative order, same operative.
Remanded back.
Disposed.
Serial number 5. Mr. K. Krishna.
Serial number 5, appear for the appellant. I'm sorry, I couldn't be there online. Sorry, I couldn't be there physically.
So what is that?
Well, this is the metro rail matter. Your lordships adjourned to today to hear the learned advocate general.
My lords, what, if I may suggest, my lords, there's a dispute with regard to the quantum of compensation that needs to be.
It may be worked out during the pendency of the.
That's what I am suggesting, my lords.
That is what we are.
No, the consent compensation is 12 crores, 10 lakhs, my lords.
Correct.
There's a dispute between few of the family members.
We have set down certain operative.
Please, my lord.
If it is okay with all of you, then we'll pass this out.
Subject to just one correction, my lord.
Subject to the final outcome, what your lordships will finally decide, man.
There is one correction. The learned advocate general is right. 12.1 crores is the value per acre.
Kindly, hold. Mr. Vikram, kindly listen the directions.
Yes, ma'am.
The
Yes.
interim direction suggested are as under. The respondent's petitioner shall hand over the possession of the land in accordance with the statement recorded in the order dated 24/1/25, if not already handed over. The BMRCL KADB shall pay compensation in favor of the petitioners at the rate of 12.10 crores per acre, along with all statutory benefits within 10 days from the date of this order. The respondent's petitioner shall not obstruct the construction of the metro line on the land in question. The above arrangement is made to facilitate the smooth construction of the metro lane and shall be without prejudice to the rival contention of the parties. In view of the statement made by learned advocate general, all parties are at liberty to negotiate and settle the dispute in question during pendency of these appeals.
Just can I make one?
Okay.
12.1, no statutory benefits comes in this, my lords. It's a consent award. So kindly, if I may request that statutory benefits may not be.
My lord, at this stage.
At this stage, man. That is the last paragraph subject to the outcome. That is already always there at this stage, man.
My lord, you are not given any consent at all, my lord. You are not given any consent for passing of the award. Respondent owners, my lord.
My lord, if we pass general award, it will come to 4 to 5 crores, my lord.
They have filed a memo, Metro filed a memo last hearing date, my lord, they are adjacent to my land. They are awarded a sum of rupees 1,06,880, my lord.
Who are you?
I have paper owners, respond number 125, my lord.
Can I just,
Landlords,
with my
my lord.
learned friend's permission, I'll clarify, my lords. I'll just clarify what my
Per
learned.
square meter, my lord, they are already awarded
Not
adjacent.
agreeable. Not agreeable.
Not agree, my lord.
Will pass general
Not
order.
agree, my
Write
lord.
down.
Then your lordship may permit us to pass a general award, my lord, so that it will come around
General
to.
award.
We adjourn it to 10th of July.
My lord, in the year 2000.
Then could my lord observe?
Mr. Ashok,
It was
there-
agreed by your senior. Therefore, you have undertaken the exercise of passing the order,
correct,
forging a kind of consensus
Consensus.
during the pendency of the appeal.
and it's just an interim arrangement.
Different ways to urge, then we'll not hear the
My
matter.
lord,
We
in
have
the
no
year,
time.
my lord, in the year 2000.
That is, your is irrelevant.
My lord,
Your is irrelevant on that day. Yes.
my lord, in the
Then
year
my lord should
2002.
consider passing the first two directions, my lord.
What is this?
Family tree, my lord. Proposed respondent nine's name is.
We are not considering
Consider-
your matter read. There is no urgency. It is irrelevant. On the next day, we'll consider. It is implement. Implement. So
We
we'll
will
say,
fi- we will
set
file
down the-
objections to the
we'll
setup.
Set down the appeal.
Then your lordship may kindly do this, except the compensation part, rest of the order may be retained
Money is lying with.
with us, my lords.
So
We'll
then
deposit before your lordships, my lords. I will deposit in the court. And except the compensation part, your lordship may say that we'll deposit before the court and rest of the portion may continue, my lords. The rest of the portion of the order may continue, my lords.
Not yet admitted.
Not it. Can I make one request, my lords? Your lordship, with one submission, the order may be written except for saying that we'll deposit the money in this court, my lords.
Notification in the year 2002. Notification in the year 2002, my lord. Till now, my lord, they have not passed any award, my lord.
The group of present appeals witnessed following order passed on 24/1 hearing the parties concerned. Then reproduce the entire order. The order is the order passed was as under. Full stop. In the facts of the case, all the appeals are admitted. This shall be listed for final hearing on 19th August.
Please.
2025. Full stop. As could be seen from the aforesaid order dated 24/1/25, from original petitioner made a statement from a recorded in paragraph 8 of the order that the possession of the land is already handed over to the authorities yesterday. It is on 23/1/25. Thus, the possession of the lands under acquisition, lands acquired
Please,
or under acquisition,
acquired,
lands acquired, yes.
lands acquired.
No, not acquired, my lord. BMRCL not acquired, my lord.
Is with the authorities. Full stop. As far as the compensation is concerned, comma, the same shall be deposited by the concerned authority with the registry of this court within 8 weeks, within
Please.
1 week.
2 weeks, my lord.
Within 2 weeks from today. Full stop. Upon the amount, what is the amount?
12 crores, 10 lakhs, my lord.
No. 3 crore, I just pointed out, 12 crore, 12 lakh is per acre rate. The, for this portion of land, 3 crore, 49 lakh.
I stand correct. 12 crores, 10 lakhs is for the 1 acre. Proportionate to their extent, we will deposit, my lord.
3,49,000.
Compensation payable to the petitioners in proportion to the extent of the land at the rate of rupees 12.10 lakhs per acre.
Per acre. Per acre.
Full stop. Once the amount is deposited, the registrar will invest the same in cumulative fixed deposit with a nationalized bank, initially for a period of 3 months and renewable.
8 weeks.
Full stop. No other restraint order operates.
Grateful.
My learned friend, because of vacations, it requires some time to deposit the money, for any reasonable.
You can deposit 3 weeks. You
Leave
can
it
do
to-
in vacation.
Grateful to.
Grateful.
No, they have lost. Now in this. They have given 5 sides. 5 sides are divided. They were fighting for those 5 sides. They have divided 3 into 3 is to that is all.
This is number 6.
Yes. See, yesterday's matter, my lord, wherein you are directed to place Kannada version of
So
the.
when the present bill comes up for consideration today, learned advocate Mr. So and so, what's your good name?
Prakash MH. Prakash MH.
Give the name for the appellants and learned advocate.
Mallikarjun NK for respond number 6, my lord.
You are also there?
My lord, he is respond number 3, my lord.
Learned advocate. No, so jointly stated before the court that the parties have arrived at settlement.
One
out of court, full stop.
Yes.
The memo
So
dated 29/4/25 is produced.
seeking dispensation of service of notice
The
to
settlement.
settlement is.
The settlement is produced. Settlement is produced along with. Where is the settlement? Memorandum of compromise is produced, which is dated 29/4/25, signed by learned the appellant as well as learned respondents, as also by the parties, that's the appellant Rudrash B and respondent 6 Jagdish Reddy. What about the other respondents?
I have filed a memo seeking dispensation of service of notice to R5, wherein my lord,
As far as the other respondents are concerned, memo dated paragraph 29/25 is filed, which is taken on the record, in which it is stated as under. So quote the memo of 29th year. Report. Full stop. The compromise, this memorandum of settlement is taken on record, paragraph. The appellant and respondent 6 are personally present in court today. They are identified by their respective learned advocates. When the court queried to each of them about the settlement reached by them, they stated that the settlement was arrived at voluntarily without any force or coercion. Full stop. The settlement deals with the apportionment of memo.
Please, my lord.
Apportionment of the development sites.
Please, my lord.
yes, please.
Allotted by
Allotted by the BDA. my lord.
BDA,
by
By, my lord, it was
Bangalore
allotted.
Development Authority.
please.
Full stop. The parties are directed to act in accordance with settlement.
Please.
And my lord,
And one request, my lord.
Based on which is on record, which is part of the record.
please. And also, my lord, since there is the apportionment of the sites, my lord, BDA has to make necessary documents, my lord. That necessary documents respect to apportionment.
Full stop. You are number 6.
Please, my lord.
This one 6 BDA, Bangalore Revenue 3 shall
I'm
Take
sorry.
up the follow-up action, shall take the follow-up action, including execution of document and following other, and shall follow other required procedures.
Yes, yes. So Lord, on the board, the memo for deletion of
You are
R5.
206.
It's a BDI represent my friend, my lord.
PDM.
So who will execute the documents?
It's respond number 3, BDI has to do it, my lord. I'm the private respondent, my lord. I'm the writ petitioner.
CDA will do it.
Please, my lord, BDI has to do it.
You are there, BDA.
Formal party, state formal party.
Who is for
BDI, my lord, is my friend.
So learned revocation BDA states that in light of the settlement between the parties as a whole, the BDA shall proceed to execute the necessary documents and complete the required procedure.
Please.
Within
3 months.
3 months.
3 months.
3 months. Within 3 months from today. Full stop. It is so directed. Full stop. The parties shall act in accordance with the settlement. Full stop. It is so directed.
Yes.
The appeal is disposed of in the aforesaid terms.
Yes. One memo is there for deletion, so if I am withdrawing it, my lords.
The
Because
appeal,
I have-
the impugned judgment and order of learned single judge shall stand substituted in terms of the settlement.
Please,
Full stop. The appeal is disposed of accordingly.
please.
Two appeals. One.
So one.
One.
Cell number 7, Mr. Pradeep Nair.
I appear for the appellant.
I appear for the respondent.
Appeal from the order of a section 9 application before the commercial court.
168, 66. Now, what is the urgency?
But the urgency is simply this one. I have filed the application on the basis that I have taken this premises on rent. I have more than 200 employees working in this office. There is renovation being done by the lessor in the rest of the building, which is causing such tremendous disturbance that my employees have been forced to work from home because the noise is above the level on which the pollution control board permits. It has reached a point where my employees are falling sick. They have had to work from home. I am unable to have meetings in office. I therefore call upon them to stop work. I write repeated notices to them to stop noisy work, at least during office hours.
Work of what?
They are demolishing parts of the building, other parts of the building where I am not, where outside my premises, which is owned by them, in the lobby especially, demolishing.
Your premise.
No, my lords. I've taken one floor on rent from them. They own the rest of the building. The lobby is where they are carrying out the highest amount of.
What is the dispute between you?
The dispute is simply that under my lease deed, it's a lessor-lessee lease deed, a dispute. Under my lease deed, they have, in addition to the normal undertakings that a lessor gives, they have said that they will give me quiet possession. They have said they will not interfere in my possession. They will not prevent me from working in the premises due to any disturbance caused by them. This disturbance has prevented me from using the premises. I have therefore written to them multiple times saying, please stop work at least for a few hours during working hours so that I can have a few meetings. My employees can come. I've produced records. I hired third-party investigators to come and record.
Still occupying the.
I have my difficulty is I have a 5-year lease deed. I have spent 6 crores to renovate the premises when I first came in 2017. 2023, they renewed it for 5 years. I have the right to use it for 5 years. But for the last more than 1 year, I am plagued by the noise levels by them, which is higher than what the pollution control board permits. I have had third-party experts come and record the time and given records to the Honorable Court as well. The Honorable Court holds, yes, no doubt you have proved that there is disturbance and it is above that what is there allowed by the authorities. However, if the noise is too much, then you should terminate and leave, which is not the solution for me because the lease specifically provides I will have unhindered use to the premises, quiet use to the premises, that they will not interfere, that they will not come in my way. And having spent this money and
You're demolishing the entire.
they're demolishing parts of the building.
If I may explain, my
Have
lords.
cut parts of the.
If I may explain, he's taken the entire second floor of the building. There are 7 floors and other tenants are also there. They have no grievance with me. Now the mezzanine, the lower basement, upper basement, the below floors are being renovated for other shopkeepers to come. Now the question is, my lords, we have reached him only second floor. We are not touching second floor. And it is not in the ambit of the agreement. Section 9 is, he cannot ask such prayers
only
to stop
difficulty is
entire
this, my lord.
construction.
The other tenants
This is
are
what they do.
above
And
me.
they have,
I
my
am the
lords,
only one who is
and they have,
facing
my
the brunt
lords,
of this.
suspended
May I
my
show-
rents.
may I show your lordship
One
two-
second. They have suspended my rents.
What is the difficulty if they are going with some construction?
Manoj, may I show two clauses in the contract and the emails that I have sent them, emails from my employees, the test reports which show that this is above what is permitted by law.
We are not granting any.
Manoj, the only relief I am seeking from your lordships today, during the pendency of proceedings, the lease deed permits me to withhold rents. The Honorable Commercial Court said you deposit the rents here, which we filed along with a memo. We deposited before the Honorable Court. On the last day, after passing this order, the Honorable Court has directed that they be permitted to withdraw it. May I please request only this, that what I have deposited may be kept by court subject to the outcome of the appeal of the pending litigation. And I may be permitted to deposit future rents also in court. That's my only request.
Pradeep Nayak for the appellant and learned advocates.
Shirish Krishna, my lords.
Shirish Krishna for respondent.
And would your lordships have this any date after vacation?
Appeal arises out of the, this is appeal.
It's a commercial appeal, Manoj.
Commercial appeal arises out of
Section 9 order.
order dated 17/4/25 passed by learned 86th. City Civil, Additional City Civil and Sessions Judge. Into the exclusive dedicated commercial court, bracket over Bengaluru, whereby application of section 9 of the Arbitration Conciliation Act of the appellant herein to be dismissed, and the respondent is permitted to finish the construction work. Full stop. It was stated in course of the hearing paragraph by learned advocate for the respondent that the petitioner appellant is occupying the second floor of the building in question in capacity of a lessee, and that the construction works which is permitted to be, which is permitted by the court is going on at the mezzanine floor and in the ground floor.
Ground, mezzanine and below floors.
And the mezzanine floor and the floor below that, below the mezzanine floor. Full stop. On the other hand, learned advocate Mr. So-and-so for the appellant stated that the amount of rent is already deposited before the commercial court below. Full stop. Overview. There shall be notice, not in the overview. There shall be notice to the respondent, returnable on, we'll say July somewhere.
Please, Manoj.
22nd July.
My lords, I am the only respondent. I have filed caveat.
Formal notice.
Grateful.
This is accepted by learned advocate who appears, who already appears. Full stop. As regards the rent amount deposited by the appellant, directed that the same shall be invested by the court below in a fixed deposit, cumulative fixed deposit with a nationalized bank, initially for a period of 3 months and renewable, and the interest which may accrue at the end of 3 months shall be credited to the savings account of the appellant. Full stop. The same shall not be permitted to, the amount of rent shall not be permitted to be withdrawn by the respondent.
May I manage the accrual? Whatever interest accrues that may be retained by the court, if they succeed in the arbitration, they can take the rents with that accrual.
We are not saying anything
Please, Manoj, please.
about future rent.
I may be permitted to deposit it before either this court or the commercial court, Manoj.
Shall continue to deposit the future rent with the commercial court below, which shall too be invested at the interval of every 2 months.
Deeply obliged, Manoj.
One submission, my lords, with my lord's permission.
Now this is over. Once
Yes,
we appoint the
I have also filed an appeal that also may be connected is my request.
appeal number.
Appeal number 251.
Why you have filed?
My lords,
Why you have filed appeal?
I have filed an appeal because there's a direction to complete constructions by July end. So my lords, by the time it comes, I would have finished my construction.
Deeply obliged, Manoj.
The list would have become infructuous by then.
Both this will be over once we appoint the arbitrator, and yours will be coming.
Yes, yes, I would have finished. I'll try to finish the construction.
Grateful.
Opposable shall be removed before the next.
Seal number, list 1, contempt matter, seal number 1, Mr. Ravindranath K.
Lord, I appeal. Lord, page number 28 is the Lord, London single judge order. Lord, the impugned communication dated 4/2/2019, issued by the fourth respondent is annexed is hereby quashed. Consequently, the fourth respondent is hereby directed to hold an inquiry and implement the order dated 25/8/2014, passed by the third respondent for
Notice 11th July.
Obliged.
Seal number 2,
Nearly 41 lakhs and 3 lakhs have been released in favor of the complainant, my lords. I've shared the set particulars with the complainant, my lord.
Kindly be called after vacation because I do not know, some calculations have been, some receipts have been given to me.
At the request of learned advocate Ms. Vaishali Hegde, stand over to when do you, July?
Please,
2nd July.
Please.
seal number 3,
It's appearing for the complainant, my lord. The order of the Honorable Single Judge, my lord, said at page 32, my lord. The subject matter, my lords, in the writ petition was challenged, my lords, to the cancellation of allotment, my lord, made in favor of the petitioner, and subsequent allotment, my lord, which was made in favor of the respondent number 2. The learned single judge, my lord, set aside, my lord, the order of cancellation of allotment, my lords, in favor of the petitioner, and also consequent orders, my lords, which were passed in favor of the respondent number 2. However, my lords, pursuant to the order of the learned single judge, my lords, the respondent BDN, my lords, now has executed a sale deed, my lords, in favor of the respondent number 2. That is at annexure F, my lord, page 38, my lord.
So what is the direction not
My
complied?
lords, direction, my lords, the impugned order, may I read, my lords, the last line.
Direction not complied with.
Direction is not complied, my lord.
Read it.
My lords, the impugned order is set aside, and this, as the same has become, as the same has been passed on an erroneous and baseless reasoning, and all consequent orders passed pursuant to annexure G are also set aside. My lord, the consequent order, my lords, pursuant to the order of the cancellation of allotment in favor of the petitioner, was that the site which was allotted in favor of the petitioner was allotted in favor of respondent number 2. That order was also set aside, my lords, by the learned single judge. However, my lords, pursuant to the order of the learned single judge, my lords, now the BDA, my lords, has executed, my lords, his allotment was also set aside, my lords, by the learned single judge. Having, my lords, the order being set aside, my lord, if your lordship kindly peruse, my lord, annexure F, page 38. Now a sale deed, my lords, in respect of which the allotment, my lord, made in favor of respondent number 2 has been set aside. In his favor, my lords, a sale deed is being executed, my lord, at page 38.
There is no positive direction.
My lords, his allotment, my lord, the allotment which was made in favor of respondent number 2 was the subject matter in the writ petition. That was set aside, my lords, by the learned single judge. As such, my lord, there is no allotment of site in favor of the respondent number 2. My lords, when there was no allotment of site in his favor, my lord, after the order of the learned single judge, the BDM, my lords, goes forward to execute sale deed in his favor, my lords, at annexure F, my lords, at page 38.
Separate petition. Taking a writ of whatever prohibition or mandamus.
My lord, in fact, there is a writ appeal also, my lords.
There, what is to be executed? Tell us. What is to be complied with?
My lords, the action of the BDA, my lords, the
Action of the VDA consequential of setting aside the order.
My lords, consequential order, which was, my lords, consequential allotment, which was made in favor of respondent number 2, my lords, was set aside, my lords, by the learned single judge. There was no allotment, my lords, after the by the order of the learned single judge, my lords, once, my lords,
What is the order which was set aside?
my lords, the allotment, my lords, order which was made in favor of the complainant was cancelled by the BDA, my lords, and subsequently, my lords, the site, very same site was allotted in favor of respondent number 2. Both the orders were challenged, my lords, before the learned single judge. The order of cancellation which was made in my favor, my lords, was set aside, and subsequent allotment which was made in favor of respondent number 2 was also set aside, my lord. My lords, after the order of the learned single judge, my lords, on 6th October 2023, my lord, they were a party, my lords, both respond BDA, my lords, and also respondent number 2, who was a subsequent allottee, my lord. He was also a party before the learned single judge. My lords, in the month of December 2023, my lords, after the order was passed by the learned single judge, where his allotment was cancelled, my lords, by the learned single judge, my lords. The BDA now has executed a sale deed, my lords, in his favor. That is, my lords, totally contrary, my lords, to the order of the learned single judge, my lords, wherein his allotment itself, my lords, was cancelled. In fact, my lords, as per the order of the learned single judge, my lords, once, my lord, the cancellation of allotment was.
So here annexure G order which is set aside was what was it order? In this order under contempt.
Please, my lord.
It is annexure
My lords,
G.
that is at page 25, my lords, annexure C, my lord.
Page 25.
Please, my lord. My lord, that
Order of cancellation of plot.
My lords,
Which was granted to whom?
to the complainant, my lord.
To the complainant.
Complainant.
So that is the only order set aside.
That is, my lords, and consequential orders, my lord. My lords, may read the second line, my lord. Consequent orders passed pursuant to annexure G. Annexure G was the order of cancellation made in my favor, and consequent order, my lords, was allotting the site in favor of respondent number 2. That was also under challenge, my lords, in the writ petition.
Where is that consequential order?
My lords, cancellation order, my lords, that is not part of the contempt petition. My lords, it was the subject matter in the writ petition, my lords. May only para 4, my lords, if your lordship kindly peruse, my lord, in my contempt petition, my lord. My lord, may read the 5th line, my lords, in my contempt para 4, my lords, page 7, my lord. On, may read, my lord. The cancellation, my lords, consequential order, my lords, was that the site which was cancelled, my lords, which was allotted to the petitioner, it was, my lords, allotted in favor of the, my lords, para 4, my lords, in page 7, my lord.
By order.
My lords,
6th October 2023. Disposing of the writ petition, learned single judge set aside order at annexure G, which was dated 1/2/17, cancelling the allotment of plot number 1308 of 1308 at Mr. Viswesvaraya Nagar. While setting aside the said order, whereby the plot was granted to you.
please, my lord. I'm sorry, my lord.
Plot was cancelled to you.
My lords, the plot which was cancelled was challenged in the writ petition.
And whereby the grant of, whereby the cancellation was set aside, comma, the consequential order was also set aside. By the consequential order, comma, the plot in question was allotted to respondent 2.
2, my lords.
Full stop. It was submitted that the allotment to respondent 2 stands set aside as a consequence of the express order passed by learned single judge. In spite of that, comma, the authorities have executed
Sale deed, my lord.
sale deed in favor of 2.
Respondent number 2, my lord.
In respect of very plot.
Please, my lord.
Full stop. And thereby the contempt is committed. Full stop. The consequence in order whereby the plot was allotted to respondent 2 is not on record. The same shall be placed on record before the next date. There shall be notice returnable.
I'm grateful.
When shall we keep? June, 17th June, 17th.
Seal number 4. Mr.
Hearing for the complainant, my lords. Order that is alleged contempt against is at page 50, my lords, dated 24th of Jan. The operative portion, my lords, will get at page 51.
Returnable. 2nd July.
Seal number 5.
For the complaint, page 13 of the complaint petition. There was a direction to the deputy commissioner.
Notice returnable. 18 July.
18?
June.
Seal number 6.
So it is barred.
Please, ma'am.
It is barred by section 20.
Please, ma'am. That annexure C is the order, ma'am.
what was happened, that the accused number 1 has filed the suit for declaration on the basis of annexure A, that. Suit has been declared, that. Against which, that complainant has filed the appeal before this honorable court, that. And after hearing, that this honorable court has
Having heard learned advocate Mr. So and so the petitioner, and having noticed the nature of the order, the court is not inclined to entertain the present contempt petition for two reasons. Firstly, order dated 30th 123, which is brought under the contempt jurisdiction, is an interim order passed in regular first appeal number 1987 of 2022. The appellate proceedings are pending at large to be considered on their merits. Full stop. At this stage, rights of any of the parties are not finally determined. Full stop. In any view, paragraph. The order was passed on 30th 123, whereas the contempt petition was filed on 16/4/25, which was admittedly beyond period of 1 year. Also, therefore, the contempt petition could not be maintained from any standpoint. In view of the
stay has been granted,
contained in
Mother.
section 20 of the Contempt of Courts Act 1971, petition is dismissed accordingly.
CC number 7. Mr. Videndra.
For petitioner in this case, single judge passed status quo order, that has been violated. In page number 16, Malaship. Parties directed to maintain a status quo that has been violated by the accused. On 18/6/2024, I given a complaint on the police
The
station.
order brought under the contempt jurisdiction is an interim order whereby learned single judge
Operative
has
petition
directed status quo in the order dated
11/12/2023.
Is an interim order whereby learned single judge has directed the parties to maintain status quo in the pending writ petition number 1670/2021 by virtue of very kind and the nature of the order, which is admittedly interlocutory order, no rights of any of the parties are finally determined, nor there is any pronouncement on merits so as to invest the order with trapping of any finality. In the circumstances, the court paragraph is not inclined to invoke the jurisdiction under the Contempt of Courts Act. The petition is dismissed.
CC number 8. Mr. Abhishek Mali Patil.
Kindly be passed over and taken up along with serial number 72 and
Not
73.
possible, beyond vacation.
No, it is
18th of July.
similar to the matters which are already listed today. Serial number 73, my lords.
Not possible.
All contempts are similar, my lords.
No. We don't have time. We are not sitting beyond 12:30. Yes.
My lords,
Number
this
9.
was listed, my lords, serial number 73 was listed
You
today.
argue and come. Is already called out. Yes, next.
Number 9.
In which case, my lords, I request for notice, my lords.
No.
Notice in serial number, my lords, 8, my lords.
Live. Work notice will issue notice.
Yes, my lords.
Is rounding off.
Yes, my lords.
Notice returnable on 12th June.
Number 9.
I take the case for the complainant, please. Page 21, the operative portion of this order, so this honorable court, page 37, bro.
Not reinstated.
Not yet, bro.
Notice returnable on 9th June.
So number 10.
I
Mr.
take the
Rangana.
complainant in this matter, my lords. Page 30, paragraph 2 is the direction, lords.
Notice returnable on 11th June.
Obligement.
So number 11. Mr. Sundaresh.
I appear for complaint in this case. Annexure, the direction, at para 4, my lord, direction is to consume my representation in 4 months.
Notice returnable on 19th June.
Seal number 12, CPL, Mr. B. M. Alaswamy.
Kindly see, my lord, the
What
petitions
is
have
the
charged.
urgency?
Urgency, my lord, now they are leveling the lands, my lord. Kindly see
What is the
annexure B at
urgency?
page 41, my lord.
What is the urgency?
Urgency, my lord, they are leveling the lands, my lord. They have leveled the lands, my lord. This is for
Yeah.
establishing the solid waste disposal unit, my lord.
No urgency.
My lord,
After-
kindly see, my lord, it has already come.
It is your business.
Respondent number 6 in this matter, Your Lordship. I'm for respondent number 6 in this
Correct.
matter, the board,
So you are in picture.
Lordship.
You are in picture in relation to the grievance. You have to respond.
Your Lordship, there is no grievance against the pollution control board. The
Because
grievance-
pollution, there is no authorization, my lord. There is no authorization as required under the rules, my lord. Consent, my lord.
But not on the last.
And, my lord, this under deckers tank, my lord.
Board is party or not?
Respondent number 6.
Please
is the
only
board.
notice.
Board, yes, board has been made party, my lord. There is no authorization by the board, my lord.
Returnable on 19th June.
My lord, may I make one submission? My lord, on 15th, my lord was pleased to direct the petitioner to convert this petition into a PIL and to supplement the proceedings and then to move the court.
Not done, not done.
Not done, I haven't got.
No, it has been done, my lord. It has been done, my lord. It's now it's a PIL, my lord. It has been converted into a PIL, my lord.
A notice returnable on 19th June. Learned additional government advocate Srimati Nilofer Akbar accepts notice on behalf of this one 1, 2 and 1, 2, 3 and 1, 2, 3 and 4. Learned advocate Miss Niyat. What's
A.
your-
Mahesh Chaudhary, Your Lordship. A. Mahesh Chaudhary.
His name is to mention.
His name.
Mr. Mahesh Chaudhary accepts notice on behalf of 6th Karnataka State Pollution Control Board. This one 5 shall be served by the petitioner. Full stop. At this stage, learned additional government advocate submitted that in view of the order dated 15/4/25, the petitioner was to supplement the pleadings relating to the public interest necessary for maintaining the public interest petition, and that the same is not done. It was submitted that the present petition was converted from private interest petition to public interest petition. Full stop. The registrar judicial is directed to examine whether the pleadings in this petition conforms, UNFO-RMS conforms the requirement of the rules applicable to filing of the public interest petition. If the petitioner is to make good the efficiencies in that regard, reasonable time shall be granted by registrar judicial to cure the defects. Full stop. The report in this regard shall be placed along with the papers of the petition on the next date of the hearing. Full stop. In the meantime, respondent to Pollution Control Board is directed to submit its report about the subject matter grievance.
Lord, I have sought for an interim order, my lord. I have completed all the rules, my lord. That's when.
No other.
My lord, now they are already leveling the lands, my lord. It's a, my lord, the tank which is under decker's tank, my lord, which is water, this entire the water which flows from the, my lord, kindly see the photographs, my lord. Entire land, my lord, the water which flows
Above
from.
observation. Except above observation. Any other interim relief is refused at this stage.
13 is
Is
urgent.
refused at this stage.
Number 13 is urgent.
You want this line to be recorded, last line? Fine. All right, recorded. Yes, next.
13 urgent. Number 14, writ appeal.
So
Initial hearing.
delay is there. We'll say returnable on 14th July.
Seal number 15 to 17 are urgent. Seal number 18.
So 18 delay.
Date appeal.
Date appeal, my
July,
lords.
notice
My
written.
lords,
Your lordships had already, my lord,
Caveator is already on record, my lords. Caveator is there, my lords.
Your lordships
This
have-
is state appeal, my lords. There's a delay of 160 days, my lords. Caveator is on the record, my lords.
Your lordships had already issued notice. Your lordships on the last occasion noted that it is covered by your lordship's decision.
Then after vacation.
My lords, there is only one difficulty may I express, my lords. My lords, the amounts are due because of which I had taken loan. My house is put to auction. Your lordships have directed for payment, my lords. This is the connected matter. Your lordships have already passed on the judgment. Your lordships have noted in the order sheet also last time, my lords.
What?
My lords, in the my lords, your lordships just have to reserve the matter because the connected matters, your lordships in the very same combination have also disposed of, my lord. My lord, may I just pass on the judgment also, my lord, for ready reference between the same parties in respect of the very same dispute, my lord.
4th of June.
My lord, my house is put to auction. May I make only to save my house, my lord.
Who is auctioning the house?
My lord, I had taken loans to make the payments. Now state government is refusing to make the payment.
The notice is issued.
My lord, auction notice is issued, my lords, which I'll have to now challenge in a separate proceedings. My lord, but if your lordships are to direct for payment, which your lordships have already directed in the connected matter.
We open for the petition challenge the auction notice in accordance with law for which liberty is reserved to move the learned vacation judge after satisfying learned vacation for the urgency.
Can I just pass on the other connected matter so that it can be listed on 4th? Great.
Next.
So, number 19. Mr. Nitin Prasad.
Appellant in this case.
Any urgency, Mr. Otherwise after it.
Yes, my lord, my road is held up. Kindly go to the last annexure, a photograph which I have produced. It is 280, I think.
Coming back to the first.
280.
We find. No urgency. Notice returnable on.
Notice may be ordered.
Notice returnable on 10th July.
Notice.
Notices. Or learned senior doctor real and draft with learner notice written. Yes.
Seal number 20. Shikha Rafike.
Intervacation.
Okay.
8th of July.
Notice may be issued, my lords.
Notice is to be issued.
Yes, my lords.
Notice 8 July.
My lords, 27th June, all the connected matters are listed. 27th June.
So next is delay. Again.
Seal number
notice.
21.
Delay. Notice
Therefore,
returnable on 14th
appellant.
July. Yes, next.
On the ground that the
22.
Notice is issued on delay. Yes.
22 is
seeking for an interim order because they have already filed contempt.
No, when there is a delay, there is no interim order. There can't be an interim order given. Yes.
Seal number 22. So commercial appeal.
22, I appear for the petitioner's counsel. It's connected with the appeals at 109.
Only. So after vacation. Judge.
Lord, yes, my lord. My learned friend had made a submission that he would give us notice if any precipitative action is being taken, as long as that is there, my lord. All
I'm
can
not-
be taken immediately after vacation.
Let the matter come after vacation. We have not given any undertaking.
9 July.
Great. My lord, June sometime, can I take a chance, my lord?
Next.
Great.
Number 23.
I represent.
Vandana PL.
There is a delay. Delay is there anyhow.
Delay is there.
Yes.
Notice returnable on 15th July.
So great.
Seal number 24. Mr. Ajay Kumar M.
Preparing for the appeal.
I'm for the respondent 2 and 3, my lords. For the respondent 4.
My lords, we have engaged the senior counsel, my lords. Kindly have it on Friday, my lords.
Friday. All.
2nd May, my lords.
25th of July. As requested by learned petitioner.
25 is 25 urgent.
Yes.
For 26.
Madam, my lord. 25 days delay is then. 25 days delay is in the.
25 already somebody is.
There is no.
26.
The other side is CC.
26 July. Next.
My lord.
Next.
There is no IA that has been served to us.
Serial number 26, my lord. Serial number 26, the notice to respond number 2 to 11 may be dispensed. They are not the contesting.
Nothing to be dispensed. Just next. There is no urgency. On the
But they have
next.
filed the execution petition, my lord. That is the
Maybe
urgency.
you seek time there. Yes.
Seal number 27. Alvin Sebastian.
Manor, for the first respondent, I may be permitted to file wakalat, Manor.
What is the urgency, Mr. Counsel? What is the urgency?
Urgency, there is an order. There is an order directing us to deposit the amount
After vacation.
on the basis of a partnership which is unsigned.
After vacation. 11th July. Yes.
There is an application for contempt, Lord. I'm appearing in the connected matter, Lord, 28.
Will not precipitate the contempt.
That could be recorded, my Lord, that they will not.
We are here seized with the appeal and contempt.
We will not precipitate.
Very good.
Your lordship may give a date if it is.
Contempt.
Given 11th.
I'm sorry, Lord. Maybe just the contempt application is filed before the trial court.
Trial court. Then you will not precipitate.
We will not
They are saying-
precipitate.
They are saying that. Trust your learned.
My learned friend knows it.
Great.
28, number 28.
Connected.
Connected matter, my lord.
29. Arjun Rao.
29, my lord, it's a fresh appeal, Lord, arising from an order under section 9 of the Arbitration Act. Lord, learned commercial court was kind enough to grant an injunction restraining the respondent from using my confidential information. But my limited grievance is, my lord, that with regard to my application for appointment of local commissioner to secure that information, ex parte relief was refused, my lord. My contention was, my lord, that in
Returnable on
my lord, my respectful submission would be, my lord, that in these cases, to secure that information, that element of surprise would be important, my lord. If he is aware that a commissioner is going to visit him.
6th of June.
Sir,
Next.
number 30, Sir PL, Mr. G.R. Mohan.
Your Lordship, in this matter, 24th March, this court directed the Sahsildar to mail a status report pertaining to the Vrishbhavati River Valley, wherein the report has been filed.
After vacation.
He made some date, Your Lordship.
18th July.
Please.
Yes.
Still number
They are required to file the
31.
report. Your Lordship.
Number 31, Mr. Raghavendra G. Gayatri, Sir PL. Mr. Raghavendra G. Gayatri, 31.
24th July.
Still number 32.
Yes.
For this one number Shilpa Rani. 4.
Nobody is there. 24th July.
Early date may be given, Miller, some in June, Miller,
June.
some date. Lord, because, Lord, this petition.
18th June.
Okay.
Number 33, Mr. Manjunath LS, Sir PL.
For respondent number 2.
It is 24th, 19th July.
Still number 34, Mr. R.B. Sadashivappa. It's a green bench matter.
What is the urgency?
Nothing urgent.
No urgency. Learned advocate states that there is, fairly states that there is no urgency. In that we put up on 9th of July.
Still number 35.
Okay, for the petition, my lords.
Your Lordship, appearing for respondent number 2, the petition has become infructuous, Your Lordship. We have already acted on the representation.
I'll just look at the recommend, may fix a date, my lords, any date after the vacation, my lords. I'll make my submissions on that.
We have issued the direction to shift the unit.
Shift the PIL.
Green bench matter, Your Lordship.
Serial number
35 minutes.
35, Your
is
Lordship.
not PIL. It's PIL.
That sought for mandamus asking respondent number 3 to be seized and shifted. We have acted on that and we have issued the direction.
I don't have a copy of it, my lords, but if that is so,
Copy will be given. Following are the prayers made in the present petition. Which was highlighted by learned advocate of the petitioner. So page 13 of the bracket portion. Today when the petition comes up for consideration, learned advocate Mr.
Rashi for Mahesh Chaudhary.
Rajasri
Rashi.
for learned advocate Mr. Mahesh Chaudhary for respondent pollution control board. Tenders memo dated 16/4/25. The said memo is taken record. Full stop in the memo. The pollution control board has stated as under. So quote this memo. In view of the above, since the board has issued communication directing respondent 2 to stop the operations of the unit, comma. The prayer stands satisfied
Please, Your Lordship.
and nothing, full stop.
Maybe dispose in terms of this memo, my lords, that's all,
Nothing
with the
stands
direction.
survive. Memo is taken on record, for लिखना. The same is, copy is served to the learned petitioner. Then nothing, the satisfies the prayer, nothing survives in the petition, it is accordingly disposed of.
Grateful.
Great.
Seal number 36, Ashok B. Mulge. 36,
It will go, it will give some date in July first. All after 10th, all after 17th July, all after 14th July, yes.
seal number 37, Mr. Abhijit.
You distribute the dates, yes.
37,
My lord, the
What is the urgency?
endorsement which is challenged is covered by the judgment rendered by this honorable court.
After
itself.
vacation,
It is a matter of 2020, sir. 5 years have been passed. The application is kept pending.
after vacation.
38, Mr. Mahendra SS.
A date may be given, sir.
Date will be given.
38, Mr. Mahendra SS.
I am here for the petition.
After vacation.
Lord, though the interim order is granted, he is unable to arrange 2 crores, Lord. Your Lordship may kindly hear the matter. Let them file the statement of objection. There was a confusion created on the last occasion with regard to the circular, the language of the circular, because there are more than 500 orders have been passed, setting aside the drone survey.
After
I was on the other side also.
After vacation, July,
June, my lord, any
no, not possible. 18th July.
Obliged.
Seal number 39 is attended. 40, to Munesh Kumar.
In this case, my lord, file one report. First week of June, my lord.
First week of June, 12th June.
So
Seal number 41, Mr. Nasim Raju.
The order of transfer. And the fourth respondent, my lord, matter pertains to transfer. The fourth,
Transfer, no urgency. 11th July.
please.
Yes.
Seal number 42, Mr. Anumat Reddy.
Filing, I served all by hand, Your Honor. During the day, I filed to this registry today.
What?
Filing the other side served acknowledgement. No, today filing.
Filing, all right. Today, learned files memo for withdrawal.
Then
It is dismissed as withdrawn.
No, kindly extend interim order, Your Honor.
This is again interim order.
Yes.
The petition is again interim order, therefore no final rights of the party are determined. In that light, the court is not inclined to entertain the, invoke the appellate jurisdiction. Appeal is dismissed. Appeal is dismissed. Tell you next.
Today,
First you said that this, second you said that this, third time you are dismissing it. What you are doing, tell us. You have some drafted good memo for withdrawal?
next time, I'm not, my senior is not there. That's why next date I am hearing matter.
You appear to be senior. Since how long you are practicing? Since how long you are practicing? Since how long you are practicing?
8 years.
8 years. What do you want? Tell us. What he wants? What he wants? After vacation. 11th June.
Number 43, Mr. K. Sridhar.
No urgency. Yes, next.
Number 44, Mr. A.T. Malya.
Next date may be given, my lord. Next date may be given. my lord.
Pardon?
Next date may be given, my lord.
Adjournment. All.
Seal number 45, Mr.
Date do you want?
Srinivas, party in person.
14th July.
45, Mr. Srinivas, party in person.
14%.
After vacation.
No, but I filed the application. I filed the application for the proposed complainant.
Who appears? 14% appears, you appear.
I'm separate. I want to include in this complainant.
That can't be done. File separate. Both can't appear.
Authority has filed the appeal, my
14%
lord.
as well as advocate both can't appear for the petitioner. Hence.
No, this is separate, my lords. This is separate.
Whatever it is separate. So what is separate?
That's here, on the very same order, he has filed the CCC up, 1081. For that, I want to implead.
No,
I
no,
implead as
after vacation.
We have filed
No,
the
no
writ
urgency.
appeal.
Very much delayed, my lord, because
Learned advocate Mr. So and so
already
appears
1 year over after passing.
to
the
press
order,
the
my lord.
impleadment application which is filed in the present contempt proceedings. Full stop. Let the prayer considered along with the contempt petition. The contempt petition shall be next listed on 25th of July.
That's here, 84 years old complainant.
Maybe it's no time.
But,
You want to go before Learned's vacation, Judge?
For last 15 years, we are struggling.
Not
to
possible.
get,
We don't have time today
my lord.
before vacation.
We have
Can
filed.
go-
Please put it in the afternoon because at least because
Not possible.
on that day afternoon you please. Sir.
Not possible.
Because my wife has gone into depression because of this case only. My
Move the-
daughter is
move the
very
vacation.
old and I cannot come in the morning, please.
We have filed the writ appeal, my lord. We have filed the writ appeal against
Writ
this
appeal is
order.
filed. So Learned, writ appeal is filed. Learned advocate Ms. So and so stated that in respect of the order under contempt, writ appeal is filed.
Listed today.
When it is listed, today it is listed.
Writ appeal also is
Today listed, my
Serial
lord.
number
Urgent. It's
140.
urgent.
113. 111.
Today listed, my lord. It's urgent, my lord.
Full stop. Both writ appeal and the contempt petition shall be listed together.
Writ appeal in August and they know the urgent.
We have said no, Mr. Part in person. Today it is not possible. Take your date.
I don't.
On say 2nd of July.
My lord, once previous matter, I was little late. I may permitted to move the vacation court, my lord.
What is the urgency?
For interior matter. Urgency, I've sought for a stay, my lord. I've sought for a stay.
Son of
Interior-
stay for what?
43 matter. Serial number 43.
Stay for what?
Stay of continuation of our servicemen.
You move, nobody prevents.
Yes. No, I was bit late, my lord. Your lordship very fast today.
No, in every matter, we are not going to pass this order. You can't, everybody is permitted to move the vacation.
My lord's liberty may be reserved to file the contempt. If at all.
All liberties are there. Yes, next.
Seal number 46.
All liberties are available.
Mr. Mohammed Dastagir, party in person.
What is the urgency, Mr. Part in person?
Agency is my lord, this PI was filed in 2020. PI was filed in
PIL is there after vacation. Stand over to 25th of July. Yes.
Seal number 47.
May I please, my lordship.
No motor petition.
My lordship, the matter is pending and the Supreme Court, Honorable Supreme Court has directed to dispose of the matter at the earliest and it has been 1 year, my lordship. Interlocutory application has been heard in April 16th and the date has been.
Can all be done after vacation. Not be even if there is over. Even if we start. Who is for the petitioner?
My lordship, petitioner, no one is appearing. my
Learned
lordship.
advocate petitioner is not present.
I am for respondent 5
The
and
order
6.
of the Supreme Court, stand out. It shall be next listed on 13th of June.
13th of June, my lordship. 13th of June. Much obliged.
Seal number 48. Mr. Sanjeev VL.
I appear for the complainant in the contempt petition, which is connected with the writ appeal, my lord.
No urgency after vacation. 18th July.
Seal number 49. Mr. Nataraj Ballad.
After vacation.
Move the vacation bench, my lord. The reason is this, my lord, eligibility criteria is challenged, my lord. Now the tender, that requisition is dismissed. And the authorities are giving the tenders to the others, my lord, even without finalizing these tenders. And we have the existing suppliers to the under earlier tender, my lord. But that has been withdrawn unilaterally without even giving us the chance to.
23.
My IA for stay is also pending, my lord. Liberty to move it over. Regards my lord's
Upon
observation.
satisfying learned vacation judge about the urgency, liberty is reserved for the petition, appellant to move the vacation court.
Oblige.
Cell number 50.
This is a contempt matter, the order of the learned single judge, is at page 12.
They are saying that they have complied with.
Yes, yes.
We have the impleading applicant.
Impleading applicant, our property has been
What is the order?
involved in this case, my lord. He has taken a, under a forged
Look at
document.
the order, at page,
Pardon,
Page,
page 13.
page
Page 13.
14. Where is the order? Page 13.
I know what needs to be done, you please mind your thing. Yes,
Have you considered everything?
We have considered the representation, we have taken note of the fact that certain fictitious documents were submitted. So we have told that unless the investigation is completed, we are unable to consider the
Doesn't serve.
request for Kata, my lords. Endorsements been issued on 2nd of January 2025 at annexure R1 along with the compliance affidavit at page 7, my lords.
The only direction in this order, in the order dated 24 June 2024, passed by learned single judge was to direct respondent to consider the representation of the petition dated 15/3/24. Full stop. Alleging contempt of the above direction, the present proceedings are filed. Paragraph. In course of the hearing today, from a learned additional government advocate, Mr. Naveen Chandrasekhar stated that the representation is decided and this in response to the representation, endorsement dated 2/1/25 is passed. The same figures on record along with the compliance affidavit.
Yes, my lords.
Full stop. In view of the above, nothing survives in the contempt petition as the direction to consider the representation has been complied with. Full stop. It is observed that if the petitioner has any grievance about the endorsement, it is always open to the petitioner to institute appropriate independent proceedings in accordance with law. In respect of it, this court does not express.
My lord,
any
in
opinion
respect
on
of our
it.
application, my lord.
The petition is disposed of.
We have filed a review petition. We may given a liberty to
Next.
pursue
Cell
the
number
review petition. my lord.
51.
Now it is over, Mr. It is-
Yes,
Because the impleading
Ramurthy.
application
Impleading application is filed by us, my lord. Impleading application, because our property
has
has
no
been
role to
involved
play,
in
my lords, in this dispute.
My lord, we have filed a review petition before the trial court, before the
Whatever it is.
honorable single judgment.
Whatever it is.
That liberty may kindly be resolved, my lord.
No liberty, this is contempt with jurisdiction. It is complete, contempt is complied with, matter is over. No impleadment is necessary. Whatever you want to pursue, you pursue in accordance with law. Why you don't understand?
That
Investing courts
observation
say.
is required because that is the main
No,
reason we
no,
have
sir,
filed an
sorry.
application, my lord.
Sorry, if you don't understand, we are not here to make you understand. Yes.
Cell number 51. Mr. S. Ramurthy. 51.
Close it.
51 years.
51.
Nobody is there, Chairman. Give date. So all contempt petition will attend up to 87. Start from 88.
Serial number 57 to 63, man.
All are adjourned beyond vacation.
Number
Filed
88.
a writ appeals, my lord.
Which one?
57 to
All are
63.
adjourned. Now 88.
Cell number 88. Mr. Deepak Bhaskar, CPL. Cell number 88.
What is the PIL? All right. Nobody is there. 25th, 24th of July.
Lords, if I make a
One
submission,
permission,
serial number
Lords.
85 contempt, I am for the accused. They have made only university party, but government is the one sanctioning authority. They have to make also government as the
Now all
accused.
have gone.
Lordship, serial number 72, Lordship.
No mentioning. Continue.
No, Lordship, I will be permitted to move in the vacation night.
89.
Liberty may be given to move in the
Lordship,
vacation. my lord.
my,
Serial number 84, my lord.
The
Lordship,
complainant is aged about 90 years, my lord.
We'll see, we'll see.
Serial number 84, my lord.
Kindly permit to give the numbers of the writ appeals, madam. I'll
For
circulate.
what?
Serial number 57 to 63, they filed a writ appeals, madam. It may be tagged with along with, I'll give the.
On the next.
Serial number 89.
Lordship, one
Mr.
submission, Lordship. Serial number 72, 76, 77, 78, 79 and 80. It is with respect to
No, I'm not there.
You mentioned at 2:30.
Serial number 84, my lord.
Yes.
The complainant is aged about 90 years, my lord.
No, 84
The
is
accused
gone.
is collecting the rents, but he is
84
not depositing.
89. Serial number 89.
My lord, at least date to fix in first week of the June, my lord.
Get the date.
First week of the June, my lord.
Get
He is
the-
aged about 90 years, my lord. He has taken shelter in the son-in-law's house, my lord.
Orders ಎಲ್ಲ ಏನ್ ಮಾಡಿದ್ರು?
We'll sit at 2:30.
Lordship, one submission.
One individual.
Serial number 98 to 109.
That's 104 needful done, my lord.
The steps shall be taken within 3 weeks, within 4 weeks.
84,
104 needful done.
84, my lord. First week, my lord.
104 needful done. 104.
84 in the first week, my lord. The complaint is aged about 90 years, my lord. He is struggling, my lord. 84 serial number in the first week, June, my lord.
This case 2nd July.
Lordship, serial number 83, the
Liberty may be given to move before the vacation.
Mention at 2:30. Please about all.
104 needful done, my lord. 104 needful done.
Pardon?
104, my lord. Needful done, my lord.
84 and complaint.
Needful done, my lord.
Complaint ಮಾಡಬೇಕು officer.
We end post.
Lordship, one submission, serial number 83, the petitioner is seeking amount for his cancer treatment, Your Lordship. Contempt proceedings have been initiated now. The respondents were issued. We were called before the bank authorities 2 days before and they informed that they have received a notice. But in the cost title here, it is showing as respondent number 2 is not served, Your Lordship. Your Lordship may kindly take up the matter today because he's seeking the amount, release of the amount for his cancer treatment. There's some urgency in the matter. Any specific date may be given after the vacation, Your Lordship.
Will be given by.
Obliged.
ಸರ್ 84 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಾ?
Up to 2:30. 2:30.
sir, namdu 230 mention ಮಾಡಿದ್ದೀವಿ.
ಹೌದು ಮಾಡಿ.
Serial number 137, believe it has been posted on 9/6, all the matters, including 137. Humble request is that there was an urgency because they were opening the ballot boxes and it was slated on Monday. Though all the office objections have been complied, all I'm requesting is it may be taken on Friday if possible. Otherwise, permission may be given or liberty may be given to move the vacation bench.
You can move. Liberty is not necessary.
Oh, but date is fixed, 9/6.
Can you file I and move the learned vacation?
That all I'm requesting is if that
You
observation.
have given in certain cases, but I am told by the registry that it is permissible to move the vacation judge even in respect of pending matters. So move it. Nobody prevents it.
Watch up.
Serial number 72.
72.
It is a series 72, 76, 77, 78, 79 and 80. Lordship, the learned single judge has directed the accused lordship to issue the marks card after rounding off the marks, lordship. And till today, we have not received the marks card. And the supplementary exams will start from May end, lordship. Before that, a decision may be taken so that we will be knowing whether we have to write the exam or we have succeeded.
Go to vacation judge. What is this? You are appealing? Appeal is pending. Then what about their future?
Lordship.
No, it's not a question of bar, my lords.
My lords, moreover, my lords.
We have first of all, my lords, lost employment opportunities, my lords, because of the fact that they have not announced our results. My lords, we have not been able to pursue a super specialty, my lords. Again, further studies also is hampered, my lords, by university not following the order, my lords. Those are the difficulties that we are facing.
Lordship.
Every day, my lords, we are losing out several opportunities. Us writing another examination, my lords, it's not for postgraduate students, my lords, it's a very lengthy process of preparing and appearing and for practicals as well. Not a small process, my lords. We have to really get, my lords, in the mindset of writing the exam if, my lords, this does not go through. The students are having, my lords, succeeded before the learning single judge, my lords. We are before your
What is the
lordships.
order? Like one matter, give one. What is the order? Let us.
May I brief, my lords? My lords, these are the PG students who have got, my lords, the minimum percentage is 200 marks out of 400 marks, my lords, under the current regulations. Now, my lords, these students have got about 197 marks. Few of them have got 198 out of 200. Few of them have got 199 out of the 200. The learned single judge has passed an order directing the university to round off the 197 marks to 200, 198 to 200 and declare them pass. There is no provision for grace marks under the provision. Despite, my lords, they are changing the marks into, they're trying to convert the marks to percentage as 197 marks is 49.25%. So 49.25%, if it is rounded off to the nearest integer, it would be 49%, not 50%. Here they have the direction is to round it off to 50% when there is no provision for grace. Our argument contention itself is when there is no provision for grace, such odd direction for rounding off is not permissible. I have filed appeals, my lord. I'll provide the numbers of the appeal. My lordship may take the appeals along with the contempt. My lords, we have filed.
Appeals have been filed and office objections have not been complied with, lordship. And moreover, lordship, the same
What is the
issue.
urgency if they are not complying with the direction? What is the urgency?
Lordship,
issue, my lords, if they issue as provisional degree certificate, my
Please.
lords, in the meanwhile, if your lordships have not, my lords, as long as there is no stay of this order, my lords, they have to comply with these directions. Because they have not even entered appearance in these matters
My lords,
or
have filed-
filed a reply.
That is a different thing. They
Revised schedule number 3 as per the university, my lords, where all of us have studied under a particular law. My lords, the previous year batch students, where these orders have been passed, my lords, they have complied with those orders. They have complied, degrees have been issued with respect to same category of students for the previous academic year, for the past 3 years, not just 1 year, my lords. For us,
Rounding of was done.
yes, my lords.
Please, Lordship.
Approved by the division bench,
students,
my
my
lords.
lords, who were
They had filed
from
appeal and appeals were dismissed.
Where is that?
Yes, I placed, my lords, before in my petition itself. Writ appeal orders, my lords, also.
My lords, there's a difference, my lords. My
There is
lordship may
absolutely
take
no
my
difference.
appeal together, my lords. My lordship may take the appeal for hearing, my lords.
In serial
I'll give in
numbers-
all the matters we have filed appeal.
Appeal after. You can move on a vacation, judge.
My lords, let it come pros. There's, my lords, one submission in the interest of students itself. In case, my lords, if they don't take up the exams in 26th of May now, their next exam is next year. My lords, if my lordship considers this order, my lords, I'm sorry.
Statement has been made. Our next exam.
That is right, maybe false or.
My lords, that's not.
Lordship, one more,
Absolutely false.
What is the?
one more
what is-
submission, Lordship.
What is the?
Let them
urgency?
appear.
My lords,
Kindly listen. What is the urgency today if this order is not complied?
yes, my lords. My lords, university, my lords, has scheduled, my lords, convocation on the 6th of May, awarding degrees, my lords, to all of them. My lords, we are going to be kept out of that, my lords,
You
convocation.
get subsequently if you succeed.
My lords, I will
Lordship,
lose
one-
out, my lords, on several opportunities, my lords. That's the only thing, my lords.
Lords, they're
Lordship,
PG
one
doctors.
submission, Lordship. Lordship, my clients who had written the,
Vacation pension ಮಾಡೋದಕ್ಕಿಂತ ನಿರ್ವಹಣೆ ಎಲ್ಲ ರಿಟ್ ಅಪೀಲ್ಸ್ ಸೇರಿಸ್ಬಿಟ್ಟು ಜೊತೆ launch ಮಾಡಿ.
Lordship, one submission, Lordship, my clients have succeeded in the NEET for super speciality, Lordship.
Yes.
If I am made to
Appeal
write
has been filed.
again,
Give my appeal
I may
numbers.
lose my
1 year.
rank.
Not listed, my lords. I'll give the numbers.
I may
Lordship may
lose a
take my
rank,
lords.
Lordship. I have succeeded in the NEET super speciality, Lordship, and the rank is around 5,000, Lordship. I may or I may not get for the next batch. That is my anxiety, Lordship. Let them give the provisional marks card and we may be permitted to complete our super speciality if they are going to drag the matter.
Learned advocate, Miss,
Farah Fatim.
for the respondent university, in all these contempt cases arising out of the very judgment and order, submitted that university has preferred writ appeal. Writ appeal. In that view, the contempt petitions will be listed along with the writ appeal. Post to all the writ appeal, in all the writ appeals, the office of justice will be removed within 3 weeks, and the same shall be posted before the approved bench on 6th of, on 9th of June.
Please. Lordship,
Office of justice will be removed.
please. Brief.
We may be permitted to move it before the vacation
To
bench.
move, nobody prevents.
Liberty may kindly be granted, my
My
lords,
lords,
since
what
it's
happens-
connected.
We granted the liberty in the first half to, in 1 or 2 cases, but I am told that there is no bar.
There's no bar, absolutely
moving
no
the-
bar.
Of even moving the pending cases before learn a single judge, provided you satisfy learned citizens about the urgency.
All writ appeals to be connected so that, my lords, if we move our contempt, my lords, all of them will get listed.
Connect.
I'll give the
Connected.
numbers.
Yes, my lords. Great.
I apologize for mentioning a fresh matter in the second appearance. The only urgency in this matter is that unless it's a transfer application, wherein, my lords, the transfer order was stayed by the learned single judge. My lords, it's a fresh writ appeal, wherein, my lords, all we have stated is that our IA for vacating the stay had been dismissed on grounds which are, my lords, in dereliction, my lords, of the orders of this honorable court, my lords, a division bench, which covers the issue. My lords, the urgency is this. If, my lords, this is posted beyond, my lords, me, the person respondent number 3, my lords, would retire by superannuation. Therefore, my lords, the transfer order will become infectious. My lords, I will leave it to my lords. My lords could give us liberty to move the vacation bench, or, my lords, list it on the second, either, my lords. My lords, we are requesting either for listing on the second, my lords, or to liberty to move the vacation bench.
Move vacation.
That's liberty could be given any time. An endorsement could be given.
It was a wrong endorsement given. You are at liberty to move on a single learner vacation judge, even irrespective of, independent of this such.
Petty serial number 45 came to be disposed of on the strength of a memo filed by the BBMP respondent number 2, where they said that the prior asked the petitioner, answer the petitioner, was satisfied. But not the memo that they have filed pertains to an order that was passed even before the petition came to be filed. This pertains, the memo that has been filed by the respondent BBMP pertains, it has an order that was passed in July 2024, 6 months before the writ petition came to be filed. Even as on the date of writ petition and subsequently, even as on date, the violation by the third respondent is still alive. So respondent number 2, BBMP has not taken any action. My only request is, the petition came to be disposed of in terms of the memo filed by the BBMP. Maybe revived, maybe kept open, maybe listed after the vacation. Appeal number 35. I've informed the counsel for the BBMP as well that I would be mentioning it because I do admit that I didn't see the date of that particular order. But the BBMP has not taken any action with regard to that particular unit, even after the petition was filed.
So the prior respondent has never applied for, that was the memo. Memo by Pollution Control Board, same matter.
Memo by the BBMP.
BBMP.
Respondent number 2 is, sorry, by the Pollution Control Board. I'm sorry, by the Pollution Control Board. I'm sorry.
They have stated that nobody has applied.
What?
Memo state that the cause of action doesn't arise for you.
No, that's what, the cause of action, they are referring to what they have filed is, was in July 2024. The cause of action arose, subsequently. I filed the petition in December 2024.
At the line, if in case of necessity, liberty to revive is granted.
So they kindly keep the petition open, have it after the vacation, because even as on today, the unit is running.
In at 35, somebody has taken. In case of.
The unit is still functioning in violation of the BBMP laws.
In case of genuine difficulty, liberty to revive the petition is granted by filing a memo in the registry.
So the request, have it after vacation. That is.
It is already disposed. On a valid ground, valid reason. Correct premise.
What the BBMP, what the Pollution Control Board did not specify is that the action was taken even before the petition was filed. So post issuing notice, the Pollution Control Board has not taken any action. And the unit is functioning as on date in violation of the pollution control norms itself. So in that regard.
Not by memo, by filing interim application. By an application. File application, whatever you want.
Please observe, that this.
It is also observed. It will be added in the order. Only 5. Only 230.
List to seal number 1, Mr. Chandrasekhar L.
Please, Lord, affidavit of complaints on behalf of respondent number 5 and 7, my Lord. 2 affidavits.
A copy may be given to us, my Lord. Lord, even as of now, my Lord, we've been checking
Sir.
the website. They have not made any change as far as these revenue records are concerned.
Could you, not this.
And my Lord, we've been here the whole afternoon.
Lord,
these affidavits are not served to us till the last minute.
Please.
Lord, may have it after vacation. Lord, we'll verify this,
Lord,
this affidavit.
para
that's
number
filed.
5, my Lord. Lord, complaints affidavit of Mr. Srikanta, who is respondent number 7, my Lord, Assistant Director of Land Records. Para number 7, 5, my Lord, I'm sorry. Para 5, my Lord. I respectfully submit that in view of the order passed by the Honorable Division Bench and in compliance of the said, notice dated 22/4/2005 was issued by the Assistant Director of Land Records. Accordingly, measurement was undertaken. After the said measurement, Pakka and Tippani dated 29/4, that is today's 4/2000 is prepared, and copy of the Pakka and Tippani dated 29 is produced herewith and marked as annexure R1 and R2 respectively. Further, Akar Band of the land is produced herewith and marked as annexure R3 and Kayam Darak Takte is produced and marked as annexure R4. OD sketch is prepared and marked as annexure R5. Para 6, my lord. I submit that Assistant Director of Land Records by letter dated 29/4, that is today's, my lord, has forwarded the survey record to the DDLR, Deputy Director of Land Record, for counter signature. A copy of the said letter is produced herewith and marked as annexure R6. It is submitted that DDLR after counter sign shall forward the same to the Tahsildar to incorporate in RTC. Thereafter, RTC will be generated within a period of 2 days. The above process shall be completed within a period of 1 week from today. We have put it on record, my lord.
And
your lordship
same
were to-
thing, not exactly the same thing, my lord, was done. Kindly look at the order of learned single judge, my lord. If my lord kindly looks at the learned single judge's order, the first paragraph says what the reliefs in the petition are. My lord, kindly see, the petitioners have sought for issuance of writ to direct the respondent assistant commissioner to approve the Podi and Durasti work already completed. Now he's saying I've done Podi and Durasti all over again. It is to approve this, then my lord, prepare form number 10. And then, my lord, the third prayer was to make appropriate entries and changes in the RTC. Now, this is the writ petition that's been allowed because there's a second round of litigation. First round of litigation, my lord, even in the contempt proceedings, they came and said, Podi Durast is over, and that contempt proceedings came to be closed. Then, my lord, I had to file the second one so that they take the next steps and make the entries in the revenue records. The prayers were precisely this, and kindly see the order, my lord. What has been the writ petition that is allowed is allowing these prayers that I have sought for in the writ petition. And today, my lord, they're saying that I have done a new Podi and new Durast. So so my lord, they have no respect for this honorable court's orders. They just want to keep us in the loop. My lord, if we don't comply with their other demands, they will just, my lord, multiply this, not comply with the orders of the court. And my lord, even in this honorable court's order in writ appeal, my lord has already recorded these facts.
They have produced the documents.
Lord, para 7, I have given the undertaking, my lord.
Kindly give me until Friday, my lord, we'll verify this.
Learned single judge.
Friday or reopening
date? While disposing of writ petition by order dated 21st September 2023, issued the following operative direction extracting from paragraph 7, page 34 for bracketed portion. Accordingly,
para 17, my lord,
as per law, the said decision was confirmed by the division bench in the writ appeal. Decided on writ appeal number was confirmed in the writ appeal number 133 of 2024. Decided on
18th December
2024, along with which the then filed contempt petition was also disposed of. The division bench paragraph passed the following directions, bracketed portion, page 24. Since the above direction was not complied with, this was a contempt petition required to be filed by the complainant in repeat, full stop. On 9/4/24, the court had an occasion to pass the following order. Pursuant to the following order, court the order 9/4/24. Yesterday, when the petition, any order was passed? No order was passed. Petition was listed yesterday.
Lord, two affidavits, my lord. One on behalf of Tahsildar, respond number 5. The second affidavit is respond number 7, Assistant Director of Land Records. Two affidavits.
It is again listed today. Again listed today. Full stop. Learned Additional Advocate General, Mr. So and so and so. This is by whom?
That is Tahsildar's.
Tahsildar.
Please.
Two affidavits.
Para 6 to 7, 5, 6, 7.
Filed by 3H Srinivas, son of Arala Nayak, working as Tahsildar, Bengaluru South, Taluka. Pandya Bhavan, KG Road, Bengaluru. It is stated that pursuant to the order passed by division bench on notice dated 22/4/25 was issued by the Assistant Director of Land Records. Accordingly, measurement was undertaken by the Office of ADLR, whereafter Pakka Tipani dated 29/4/25 is prepared and copy prepared, full stop. The Akarband of the land and the Kayam, Tara, Sakte is produced on record. 4D sketch prepared by the office of ADLR, it was stated. Paragraph, it is stated that the same is further processed, having been forwarded to the DDLR for counter signature. The DDLR after counter sign shall be forwarded to the Tahsildar to incorporate in the RTC. It is stated that the RTC will be generated within a period of 2 days. Full stop. In the other affidavit filed by? Other affidavits filed by?
Other is, my lord, respond number.
Filed by the Assistant Director.
Respond number 7, my lord.
There is Bengaluru South, in which also the same averments are made, and it is stated that assistant, and it is finally stated that the Assistant Director of Land Records by letter dated 29/25 has forwarded the survey records to the DDLR for counter signature. The RTC will be generated after completing the necessary procedure within a period of 2 days.
And para 7 undertaking given.
It is stated that the entire process will be completed within a period of 1 week from today. Full stop. In view of action taken by the above measures taken by the authorities, the contempt the compliance is obtained, the contempt proceeding does not survive.
May I make one submission? May I make one?
R5 and 7 are personally present before this honorable court, my lord. That same can be dispensed with.
It was stated by learned additional government that Tahsildar,
please,
and the Assistant
Director of Land Records,
so are personally present. The presence is taken note of and shall stand dispensed.
Please.
And the presence is disposal of the
please,
contempt petition after compliance.
please.
The authorities are directed to act in accordance with the advertisement in the
please. My lord, may kindly
Lord,
my lord, since I said kindly grant us some time to verify this, and my lord, grant us liberty to move court to reopen this matter in case, my lord, we find that this is not complied with.
You can move again.
No, my lord, kindly see, the issue is the prayer that was sought for was specifically with regard to making revenue entries also. Those revenue entries, even according to these affidavits, is not done. I'm not, all that I'm seeking is 2 days time. My lord, and they are saying they need 2 days time to comply with that order. My lord, if it is not done, kindly give me the liberty of
If contempt is there, we will not leave up to the end. If the contempt is purged, we will not keep pending contempt for a moment.
my lord, my lord may close the contempt, my lord. I'm only saying, if in case the contempt persists, my lord, if on verification, if I find it persists, kindly grant me liberty to move.
An undertaking is given in the affidavit, what else will not? This is something.
We have said that they will act in accordance to your method.
This is list one, number 139.
Lord, I apologize, my lord, if at all
It is
from
gone
our
now.
side.
Things have gone. Why do we? These all are part of the. Nothing personal. Nothing personal. Yes.
Lord, just said.
139. What is that? 230.
Preparing for the complaint, my lord.
Grateful.
Appear for the accused, my lord. On the previous occasion, this honorable court had made certain observations, my lords. We have issued the reinstatement order of the.
My lord, as per my instruction, my lord, they told that for posting, they after disposal of the review petition only, I will give a posting, my lord. If I request to give posting, my lord.
Posting will be.
May I kindly, I have filed a memo, my lords may kindly take it, my lord.
On 22/4/25, the following order was passed by the court. Court the entire order. Today, when the contempt petition comes up, consider the same learned advocate, Mr. So and so, with the respondent stated that yes. What you are filing?
Court of
Anything?
Memo has been filed.
Oh,
It
is
filed on
Already
28.
filed?
It is.
That the memo is filed.
Page 2, my lord.
Showing the compliance and that complainant has been continued in service.
Yes, reinstated in service as per.
Having been reinstated.
Subject to final.
He is communicated by registered post. The reinstatement is on the post of.
To the post of gangman.
Gunman. Full stop. The contempt stands purged. The proceedings. Office order dated
25/4/2025.
Office order number 82 of 25 dated 25/4/25 is produced.
Subject to result of final review petition, my lord. They are given.
In which it is stated.
No
that
difficulty.
Reinstatement will be subject
At
to
least
final
posting may be
review.
directed to give posting, my lord.
My lord,
So orally, they told
we
that
have-
after disposal of review petition only, they will consider for posting, my lord.
may not be accurate. We have informed the person. He has come to the office. We have given him the copy of the reinstatement order, but he's not received it and he has returned back. Probably he intends to collect it through the court. He reports, my lords, there's no harm in.
Willing to join the duty.
I will inform, my lord.
Learned advocate for the petitioner states that the petitioner would approach the authorities and that and shall join the
Necessary posting orders will be.
duty. Join the duty.
Please.
In view of the posting order already given. In
Please.
view of the above, the contempt proceeding does not survive. They are dropped and the petition is disposed.
Grateful.
Obliged.
so number 140, HR Chori.
Last time, this one court directed me to file affidavit, my lordship, filing affidavit.
What is it? What is it about?
Really?
The inquiry had to be
Lordship,
completed.
completed.
Madam, Lordship had directed the affidavit of the concerned officer, so they are filing the said affidavit.
Sir,
That's the contempt may be kept open because they say that they'll hereby undertake that the inquiry will be completed and concluded on or before 23rd
Para
May
10 laws.
2025, Malad. That is prior to the expiry of the term. Malad, if they do not comply with the terms of this affidavit, Malad, they'll have to approach this court again, Malad, by way of another contempt. So this may be kept pending till 23rd by 2025, Malad. Thereon, if they
On this
conclude the
contempt
inquiry.
petition, following order was passed by the court on 24/4/25. For the entire order. In response to the order, when the contempt petition comes up for consideration today, affidavit on behalf of the member secretary of the Rajya Dharmika Parishad has been filed today, in which it is stated on oath that the inquiry will be completed and concluded on or before 23/5/2025. That is prior to the expiry of the term of the managing committee. Nothing further survives in the.
Malats, it does
present
survive,
contempt
Malats. May I
proceedings.
make one
That is
submission?
disposed of.
Malats, my only apprehension is that, Malats, if they do not comply with the terms of this affidavit, Malats, I'll have to approach this court again on this very same issue, Malats. So it may be kept pending. It does survive, Malats.
Number 141. Mr. Virupaksha PH.
For the petitioners.
My lords,
The direction of the learned single judge, my lords, was to continue the petitioners, my lord, on daily wage basis, my lord, page 26, my lord, last 2 lines. Respondent number 1 is directed to continue the petitioners on daily wage basis as scavengers till regular recruitment, my lords, is made. On the last occasion, my lord, I had submitted to your lordships, my lord, that an affidavit, compliance affidavit, my lord, is filed. However, my lord, they wanted to take back the petitioners, my lord, through a private agency. As such, my lord, lordship had adjourned this matter, my lord. Today, learned
we have
government.
got them redo it by the letter dated 28/4/2025. So I have made it sure that they directly report to the concerned office as such. The last paragraph could page 5, my lords. The last paragraph, the translation is a little wanting, my lords, but in page 2 in vernacular language, it's clear, my lords. We have used the terminology to directly report to the concerned office, my lords.
But the grievances that you are appointing through agency.
The grievances that we had earlier written a communication telling you report through the outsource agency. Now we have used the terminology that you directly report to us as such.
Please, I'll directly, the direction was to continue us in the department. We will directly report, my lords, to the first respond department, my lord.
Page 2 in vernacular language, it's clear, my lords.
That is the commissioner, my lord, Hindu Religious Institution and Charitable Endowments Department.
What is the last order passed in this?
Lordship had only adjourned the matter, my
My
lord.
lordship said orally indicated, my lord, so we had to redo it, my lord.
The direction which is to be complied with. The direction of learned single judge in order dated 13 December 2022. Is that respondent 1 is required to continue the petition on daily wages basis as scavengers till regular recruitment is made, and also to provide the petitioner opportunity to participate in the regular recruitment process. Also, the grievance of the petitioner was that he is employed by he is given employment through agency by the respondent commissioner from a Hindu religious institution and charitable endowment department, Bengal. It is the case that petitioner is to be treated as employee of the endowment department. A memo dated 29/4/24/5 paragraph is filed by learned additional government Navin Chandra with which produced this copy of communication dated 28/4/25, whereby the petitioners are required to directly report to the department for joining the duty, full stop. Learned advocate for the petitioner states that the petitioner will accordingly directly report
Please.
to the department and will join the duty
Please.
under the department.
Under the please.
Full stop. In the above view, the present contempt petition does not survive. It is disposed of. Parties shall act in accordance with the obligations incurred.
Please. Great.
Number 142,
Right,
Mr. Shiv Shankar White.
Complaint is.
Complaint, my lord, may I pass on, my lord, the memo.
Last.
My lord, the memo may I pass on, your lord.
On last date of hearing, my lord, this honorable court, my lord, sir.
My lord, kindly pardon me, my lord, it is in Kannada. The sum and substance is, my lord, the issue is pending before the executive officer of Taluk Panchayat. Now it is resolved. My lord, within 4 weeks from today, we will comply the order, my lord.
My lord, sir, on 8/8/2023, my lords, the honorable single judge, my lords, directed to carry out inspection, my lords. On 18/8/2023, my lords, inspection is conducted, my lords. And on 14/9/2023, my lords, they are clearly stated before the single judge, my lords, there is private respondent, my lords, they are not obtained license and plan sanction from the Gram Panchayats, they are constructed building, my lords.
Which is the order and the contempt?
My lords, order is, my lords, annexure A, my lords.
29? No. Next.
Let's,
It's page 9, my lord.
9, my lords, kindly come to page 12, my lords, operative portion is page 12, my lords. May I read, my lords?
So for concluding the inquiry.
Please. But between private parties, my lord, the issue was pending before, my lord, executive officer Taluk Panchayat. There was an interim order subsisting till, my lord, March. Recently it was disposed of. Pursuant to that, my lord, within 4 weeks we will comply the order, my lord. That is my.
In spite of the interim order, my lords, the private respondent, my lords, they completed the construction, my lords. Even they are not bothered about the interim order. Now, my lords, the respondent, my lords, on 25/1/2025, my lords, issued notice to respondent, my lords. Except issuing notice, my lords, they are not taken any action, my lords. From 25/1/2024, they are not taken.
After vacation disposed. 10th of June.
Kindly direct them to conclude the inquiry.
Well, meanwhile, I will come, please, my lord.
They have stated.
I have stated, I filed a memo, my lord.